Kraken asks court to dismiss second claims to avoid significant reordering of U.S. financial structure. Judge William H. Orrick is scheduled to hear the matter on June 12. Kraken's lawyers have asked a court to dismiss second's claims against to avoid a significant reordering of the U.S. financial regulatory structure. The matter appears to be boiling down to whether the second has jurisdiction over the cryptocurrencies Kraken listed. Crypto exchange Kraken has asked a U.S. court to dismiss the claims brought against it by the U.S. Securities and Exchange Commission second to avoid a significant reordering of the U.S. financial regulatory structure, according to court filings submitted in the Northern District of California on Thursday. The second initially sued Kraken last November, alleging it did not register as a broker, clearinghouse, or exchange. This was months after settling charges over Kraken's former staking service. In February 2024, the crypto company moved to kick out the second's lawsuit. It argued that cryptocurrencies, at least those listed in the second's complaint, should be treated like commodities and not securities, CoinDesk reported earlier. Last month, the second filed a 39-page opposition to Kraken's motion to dismiss, in which it said it is simply not the case that this enforcement action exceeds the authority Congress granted the second. The second was created by Congress to enforce the Securities Act and Exchange Act, including the requirement that securities intermediaries register with the second, the filing from April said. In applying the Howey test in its determination that Kraken must register, the second is simply following its congressional mandate. The second further argued that it is not assuming new powers and Congress does not need to enact bespoke laws to each new technology that emerges. Kraken's latest reply to the second's motion to dismiss hinges on the extent to which one can interpret the second's jurisdiction by using the Howey test, which determines what is and is not a security. It does so by determining whether four criteria are met: an investment of capital in a common enterprise with the expectation of profit driven by the efforts of others. The second cannot satisfy Howey's additional requirements that there be investments of money in a common enterprise with a reasonable expectation of profits based on the efforts of others, Kraken's lawyers wrote. This would gut Howey by significantly expanding the second's jurisdiction to a host of investment activities that were never delegated to the agency. Such a significant reordering of the U.S.'s financial regulatory structure should be debated in Congress, not in the courts. Judge William H. Orrick is scheduled to hear the matter on June 12. Nick Heilishtet contributed to this report.